Hello everyone and welcome to today's AVIL webinar. My name is Emily Ebden. I'm a National Hep C campaign and capacity building lead with AVIL. I'll be facilitating today's webinar, which asks this question: can stigma perpetrated against people who use drugs be interpreted as a form of torture and a violation of human rights? Okay. Might just do a bit of housekeeping now. This webinar is recorded, but only panelists' audio and video is captured. And just a reminder to put all questions in the chat. Okay, I'd like to do an acknowledgement of country now. I would like to acknowledge the traditional custodians of the lands on which we live and are meeting from today. I'm meeting from Nipalina Lutruwita from the lands of the Milwanina people. I pay my profound respects to elders past and present and emerging, and those that didn't get to reach elder status due to colonisation. It always was and always will be Aboriginal land. I'd also like to thank Aboriginal and Torres Strait Islander people who are part of AVIL's network and community for the valuable contribution they make to the lives of our people, our environments, our communities and our work. And now I'd just like to do an acknowledgement of community. Today I would like to acknowledge the legacy of the peers who went before us and those who continue to strive for equity, social justice, and in the face of criminalisation and intense stigma and discrimination. We wouldn't be here today without our founding peers. Okay, I'd like to introduce our panellists now. Our first, we have Professor Kate Seear. Professor Kate Seear is a professor at Deakin Law School at Deakin University. Professor Seear is a leading expert on alcohol and other drug law, policy and practice. She has written widely on issues including the human rights of people who use drugs, Hep C and injecting drug use, stigma and discrimination, drug use and gender, harm reduction, family and sexual violence, legal practice and legal ethics. She also has expertise in health and human rights. And next we have Dr. Sean Mulcahy. He is a research officer at the Australian Research Centre in Sex, Health and Society with a research focus on human rights law and experiences of stigma and discrimination against marginalised populations, including people with a history of Hep C, people who use drugs and LGBTIQA+ people. And finally, we have Professor Carla Treloar. Professor Carla Treloar is Scientia Professor with the Centre of Social Research in Health and Social Policy Research Centre. Carla's research interests are in the fields of Hep C and injecting drug use. She is primarily a qualitative researcher and is grounded in the disciplines of health and social psychology, public health and health policy. Welcome everyone. Thanks for being here. Hi, Sean. I'll let you take over.
Thank you. And I'll just start by sharing my slides. Wonderful. So thank you, Emily, and thank you for the opportunity to speak with you all today. I want to begin by echoing the acknowledgement of traditional owners of the lands on which we meet, and also warn that today's community briefing will contain discussions of a deceased Aboriginal person. I also want to acknowledge the ongoing impacts of colonisation, including higher rates of drug use and relatedly drug use stigma amongst Aboriginal people. Our work was supported by the National Health and Medical Research Council, the Australian Research Council, and the Australian Government's Department of Health. And our presentation today is based on an article that is forthcoming with the International Journal of Drug Policy, which will be free access for all. So the World Health Organization has recognized that stigma against people who use drugs is a key contributor to poorer health outcomes. And whilst international drug policy increasingly recognizes the need to address drug use stigma, there's limited consideration of how drug use stigma can be addressed through legal frameworks. So this community briefing will consider the role of law in one respect, through a focus on the relationship between drug use stigma and human rights law that prohibits torture and cruel, inhuman, or degrading treatment. In doing so, my colleague Professor Kate Seear will speak about a landmark Australian coronial case that involved an Aboriginal woman who died while incarcerated after not receiving adequate care for her acute opioid withdrawal symptoms. In this case, the coroner found that this lack of care was caused by stigma and constituted stigma as a form of cruel, inhuman, or degrading treatment, or at the very least, raised the possibility that stigma could constitute a form of cruel, inhuman, or degrading treatment under human rights law. And we argue that this framing carries potential implications for the legality of stigma in Australia and other jurisdictions that prohibit torture and cruel, inhuman, or degrading treatment. So coming to the matters that are on this slide, torture has long been prohibited under international human rights law. Article 7 of the International Covenant on Civil and Political Rights stipulates that no one should be subjected to torture or to cruel, inhuman, or degrading treatment. And Article 1 of the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment of 1984 defines torture as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him, and please excuse the gendered language here, or a third person, information or a confession, punishing him or a third person for an act that has been committed or is suspected of being committed, or intimidating or coercing him or a third person, or for any other reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of, or with the consent or acquiescence of a public official or other person acting in an official capacity. Article 16 of the Convention prohibits other acts of cruel, inhuman, or degrading treatment which do not amount to torture. Importantly, the Convention does not provide a definition of cruel, inhuman, or degrading treatment, rendering this a potentially capacious prohibition. At the time of speaking, 175 nation states are party to the Convention and its prohibitions on torture and cruel, inhuman, or degrading treatment, and 174 are party to the International Covenant on Civil and Political Rights. Now, considering that there are 193 member states of the United Nations, it can be said that there's a broad uptake of this prohibition on torture and cruel, inhuman, or degrading treatment internationally, including in Australia, which is the focus of this community briefing. Now, Australia is a party to both the Convention and the Covenant, and torture and cruel, inhuman, or degrading treatment is prohibited under Australian human rights law. For example, Section 10 of the Charter of Human Rights and Responsibilities Act, which operates in the state of Victoria, provides that a person must not be A, subjected to torture, or B, treated or punished in a cruel, inhuman, or degrading way. Similar provisions exist in the Human Rights Acts in the Australian Capital Territory and in Queensland. There is, however, no National Human Rights Act in Australia and no Human Rights Acts in the state of New South Wales, Western Australia, South Australia, Tasmania, and in the Northern Territory, meaning that the human right to protection from torture and cruel, inhuman, and degrading treatments not codified nationally and in these subnational jurisdictions. There is an active campaign for an Australian Human Rights Act, and you can sign up to the Human Rights Law Centre's campaign at the link that's on your screen, and I'll also pop that in the chat during the discussion. Torture is, however, also prohibited under the criminal law. For example, the Criminal Code of the Commonwealth states that a person, being the perpetrator, commits an offence if the perpetrator engages in conduct that inflicts severe physical or mental pain or suffering on a person, and the conduct is engaged in for any reason based on discrimination of any kind, and the perpetrator engages in the conduct either in the capacity of a public official or acting in an official capacity, or acting at the instigation or with the consent or acquiescence of a public official or other person acting in an official capacity. Under the Criminal Code of 1899 in Queensland, a person who tortures another person commits a crime, regardless of what capacity they're acting in. And a similar provision exists in the Australian Capital Territories criminal law, except that it only applies to a person who is a public employee or acting in an official capacity, or is acting at the instigation of or with the consent or acquiescence of a public employee or a person that's acting in an official capacity. In addition, the Criminal Code of the Commonwealth only prohibits cruel, inhuman, or degrading treatment in the context of persons being detained. There's no specific crime of torture in New South Wales, Victoria, Western Australia, South Australia, Tasmania, and the Northern Territory, and no specific crime of cruel, inhuman, or degrading treatment outside of the Commonwealth, where again it's only prohibited in the context of persons being detained. However, infliction of pain or suffering may be covered under other criminal provisions against causing injury, which generally includes both physical injury and harms to mental health. So in summary, the human right against torture and cruel, inhuman and degrading treatment is haphazardly covered by an assortment of laws that exist in all Australian jurisdictions. And the relationship between torture and cruel, inhuman or degrading treatment and stigma was recently explored in the finding into the passing of Veronica Nelson, which is the only decision that we could find in a search of case law in those Australian jurisdictions with a Human Rights Act that relates stigma to torture and cruel, inhuman and degrading treatment. And what we argue is that this case has potentially significant implications for how drug use stigma is understood and for the obligations of a wide range of public authorities and officials to act in a non-stigmatising way. I'll hand it over to Kate now to talk about this case.
Thanks very much, Sean. And Sean, I'll just ask for your help if I can to skip through the slides. So if you can go to the next slide for me, Sean, that would be great. So before I delve into this case, I just want to begin by acknowledging that the circumstances of the death of Veronica Nelson are very difficult. They make for difficult listening, that they're very confronting. And some time ago, when we first started doing work on this case, we sought the permission of Veronica's senior next of kin, who has themselves now passed away, sadly, to do this work. And he was very supportive of the work, in part in the hope that by reflecting on the case and continuing to talk about what had happened to Veronica, we might be able to mobilise and for the outcome of that case to lead to some real meaningful change. So it's a very large decision. It's publicly available if you'd like to have a look into it. You can see on the slide there that I make the point that it's a very large judgment that spans more than 360 pages. So we could, there's much that could be said about this case, but today we're focusing specifically on key aspects of the findings that relate to drug use and, as I'm going to step you through in a moment, that relate to stigma, torture or cruel, inhuman and degrading treatment in the context of what Sean was just taking us through. So the decision into the findings into the passing of Veronica Nelson were handed down in January 2023 by a Victorian coroner named Simon McGregor, who had conducted an inquest into Veronica's death. Veronica was a 37-year-old Aboriginal woman who had died in police custody. And as I'm going to explain, the coroner did the work of bringing together concerns about drug use or drug policy and law and practice with stigma and human rights in a way that we think is very novel and that we think has implications for the entire AOD sector. So the circumstances of Veronica's death are tragic, and I'm going to do my best to avoid repeating some of the worst aspects of it here because I know the case is deeply unsettling, but I do need to take you through a very brief summary of what happened to Veronica in order for the decision to be, for us to be able to understand and discuss its implications. So on the afternoon of the 30th of December 2019, Veronica was with her brother at a train station in central Melbourne. She was stopped and arrested by Victoria Police on outstanding warrants. She had been accused of minor thefts. She was taken to the local police cells. She was interviewed and remanded overnight in custody. Veronica represented herself in court the next morning, where she applied for bail, but that bail was refused. And she was then transferred in a van to the local women's prison. Now, Veronica had a long history of injecting drug use, and she became unwell during that transit to prison. She was sick in the van en route. And then when she made her way to the prison over the next 36 hours or so, she was sick on several further occasions, and she used the prison intercom to request help on 49 occasions. She was given some help, but there was also evidence at the inquest that her complaints were ignored. So, for instance, one doctor said that Veronica was simply withdrawing from heroin, and I'll quote from that doctor here, who said that, although I'm sure that's incredibly uncomfortable, that's not very sick. One nurse gave evidence that people who experience withdrawal symptoms are, quote, just withdrawing, again, as opposed to being sick and in need of care. So the implication of some of this evidence was that sickness is an inevitable part of withdrawal, as opposed to a medical problem in and of itself that might require treatment. Now, very sadly, Veronica was found dead in her cell on the morning of the 2nd of January 2020. We'll go to the next slide. Thanks, Sean. So the coroner made a total of 51 findings and 39 recommendations, and across a very wide range of areas. And as I said, if you haven't done so already, it might be worth going to the case to look through that because it's a very comprehensive and significant decision. But his key finding was that Veronica died of complications of withdrawal from chronic opiate use and a condition called Wilkie syndrome in the setting of malnutrition. Now, in Victoria, a lot of attention has been paid, I think quite rightly, to the bail laws in our state and how it was that Veronica ended up in custody in the first place. But I'm going to sidestep those questions here because we want to focus on a finding that's received less attention, at least publicly, and that is a finding which we think asks very searching questions of healthcare systems more broadly. And this was the finding that key staff had, in the words of the coroner, failed to take seriously their obligations to Veronica, and that this was, quote, linked to an assumption that suffering and unwellness was normal for a prisoner experiencing withdrawal, end quote. The coroner went on to find that, quote, the normalisation of the suffering of women experiencing drug withdrawal results in the desensitisation, end quote, of staff to such withdrawal. And that this desensitisation had, in his words, made some staff virtually unresponsive to Veronica's persistent pleas for assistance and blind to her clinical deterioration, end quote. He went on to conclude that this was, quote, evidence of pervasive stigma, and crucially, that this stigma, quote, causally contributed to Veronica's passing, end quote. Now, the coroner went on to find that stigma was inherent in some policies and practices governing Veronica's care. This included, for instance, the fact that relevant corrections policies that governed the treatment of patients permitted no clinical discretion regarding the dosage or type of opiate substitution therapy or pharmacotherapy that treating medical practitioners might provide to prisoners. Instead, prisoners were offered simply a standard withdrawal pack. The coroner also found that it was inherently stigmatising that prisoners, and I'll quote from him again here, that prisoners are inhumanely not afforded the suite of pharmacotherapy that would otherwise be available to them within the community, such that they might be effectively forced into involuntary withdrawal, and, quote, that prisoners who do access substitution therapy may be removed from the program for non-compliance, end quote. Now, importantly, Veronica's treatment, in the words of the coroner, was inhumane, cruel, and degrading. So here we see the coroner referring back to that language that Sean introduced us to just a few moments ago. This is language that appears both in the convention, the covenant, and also in that domestic legislation, the Victorian Charter on Human Rights and Responsibilities that Sean was talking about a moment ago. The coroner also found that drug-related stigma had helped shape the nature of care that Veronica received, and that stigma had contributed to her death, and that these were violations of her human rights. So in other words, we argue the coroner found that Veronica died partly due to stigma, and that this stigma was a violation of her human rights, including her right to be free from cruel, inhuman, and degrading treatment. Now, I just want to move away from the specific facts of the case for a moment and put aside the fact that the case is about drugs, the fact that it's about the actions of people working in a women's prison, and think about the fact that, think about what happens in a range of other settings where people who use drugs might be present. That includes places like hospitals, rehabilitation centres, police stations, and so on. I'm going to come back to the significance of those settings in a moment, but I just want to distill the case to its fundamental point. I think what the coroner is saying, in essence, is that stigma really matters, and that to stigmatise people who use drugs might be a legal wrong in and of itself. So if we can go to the next slide, thanks, Sean. I think that the coroner is really saying this: stigma matters, that stereotypes and assumptions about people who use drugs and their health and health needs and behaviours, including in the context of withdrawal, matter and must be paid attention to, that sweeping generalisations or assumptions about what will be good for people who use alcohol and other drugs, which might include, for instance, that it's good or normal or natural for them to go through this period of withdrawal and just to sort of tough it out, or have to endure that kind of experience, can be stigmatising, can be unjustified, and potentially also unlawful. I think the coroner's finding also tells us that people who use alcohol and other drugs must have access to equal treatment and care. That includes substitution therapy or pharmacotherapy. That practices that are humiliating, shameful, or demeaning, like leaving people to suffer, for instance, for long periods of time, might be unlawful. And of course, at a bare minimum, that we must get better about how we treat people across settings. And that's not just confined to the prison setting, even though Veronica's death, of course, occurred in custody. So these findings matter for a number of reasons, including because stigmatising people who use alcohol and other drugs, treating them with sort of tough love, is so often a feature of drug policy and practice. Suffering is often treated as inevitable in some of these contexts, or even as a kind of good that is a necessary part of helping people to move beyond alcohol and other drug use. And so, as we can see on this slide here, in the case of Veronica Nelson, the coroner found that various acts and omissions in the course of managing people who use alcohol or other drugs can be stigmatising, and we suggest that these kinds of stigma might be unlawful or a human rights violation in the sense that they are cruel, inhuman, and degrading. And this is a very important departure from the way that alcohol and other drug policy, law, and practice is often thought about. As Sean mentioned at the outset there, we have recently had a paper accepted on this point in the International Journal of Drug Policy. In fact, just last night we had it accepted, and so that will be forthcoming soon and will be available publicly that everybody can read. But I have also written a chapter about the case for a forthcoming book. Again, not yet out, but you're welcome to contact me and I'm very happy to share that with you. That's a book that looks at important cases from around the world, and I focus on this case, arguing that one of the reasons it matters is because it breaks with certain long-standing habits in law and legal thinking when it comes to drug use, including those that naturalize drug-related suffering or treat drug-related suffering as normal, inevitable, or even necessary. The case really challenges the tendency to think about these forms of suffering as either deserved or acceptable, normal, natural, or inevitable. And we think it also calls into question punitive approaches to people who use drugs, including the use of treatment or withdrawal for punitive purposes, as well as inadequate or insufficient access to treatment and the lack of person-centered care. So we might reflect on how this approach differs to how people are treated in very diverse settings. And this is where I want us to think about the potential significance of the case outside the context of a prison setting where somebody might be undergoing essentially involuntary withdrawal. Let's think about settings like the administration of pharmacotherapy, or contexts where both voluntary and involuntary drug treatment are being administered. Let's also think about settings such as drug courts. In these settings, shame, humiliation, and other kinds of embarrassment are sometimes present. They are also sometimes assumed to be helpful and necessary. We might just go back a slide, Sean, if I can. I'll come to that one in a moment. Thank you. So in these sorts of settings, as I mentioned, shame, humiliation, and other kinds of embarrassment are sometimes assumed to be helpful and necessary. They're sometimes thought of as a means to initiating change or to encouraging people to stop using drugs or to engage in abstinence, or as essential for fixing apparently disordered people. So we might reflect on what it means in a context where, for instance, many First Nations people might feel particular forms of shame about seeking out care or help in the first place, including because they may anticipate or fear being shamed, and whether there are ways to safeguard against these forms of shame. Of course, the point holds for people who use drugs more broadly as well, where the potential for shame, humiliation, embarrassment, and cruelty are particularly acute. A range of policing and other practices might be called into question when we start to think about things through this approach. So the case raises questions for the AOD sector as a whole, as well as for any settings in which care is provided for people who use alcohol and other drugs, and where the possibility of shame, indignity, and humiliation can be found, as well as contexts where suffering might be present. Now, last year I was invited to the Northern Territory to give a talk on human rights, stigma, and the law. And again, I chose to talk about, in part, this case because we feel it's a significant one. And in order to further illustrate how we might think about stigma, indignity, and AOD more broadly, I drew attention to a local example that I thought might resonate with people up in the Northern Territory. And I want to share it again here to help illustrate the point. I drew there on some very important work that was being done by Mick Gooder, who many of you will recall was the Aboriginal and Torres Strait Islander, Social Justice Commissioner. For the Australian Human Rights Commission from 2009 to 2016. And right back in 2010, Gooder delivered an important address to the National Press Club in Canberra. And there he was talking about the Northern Territory emergency response, which of course was known as the Northern Territory intervention. Gooder was making the point that this was an example of a practice that dealt with, in this case, alcohol principally, that unfairly stigmatised Aboriginal and Torres Strait Islander people. And this on the slide is what he said, and I'll read it out. He said, each of the intervention communities had big blue signs erected outside them, which among other things, loudly proclaimed restrictions on alcohol and pornography, as if everyone living behind those signs are alcoholic, perverts and perpetrators. I invite the residents of Yarralumla, Red Hill, Wallara, Mossman and Toorak, to name just a few well-known middle-class suburbs, to contemplate how they would feel with similar signs erected at the entrance to their communities. These signs continue to diminish the people living behind them, and they diminish us as a nation. Now, later he went on to argue, and we might just go back a slide, Sean, if we can. Thank you. We'll stay there for a sec. Now, later, Gooda argued, and I'll quote again here, that while alcohol misuse is an Australia-wide issue, it is only in Aboriginal and Torres Strait Islander communities where adults are criminalised for the consumption of alcohol across an entire community. Now, this is a very different setting and context to that of Veronica Nelson's treatment and ultimate death. But I raise it here because, as I see it, Gooda was concerned not only with drawing our attention to policies and practices that target or single out Aboriginal and Torres Strait Islander people and people who consume substances, but with the way in which these policies are communicated and implemented. And that's the key point. How are these policies communicated and implemented? Gooda's remembrance of the Northern Territory intervention, I think, resonates strongly with the coroner's findings in Veronica Nelson's case, because here he's drawing attention to the possibility that in the process of providing or implementing a policy or practice, it's possible that people will experience stigma, humiliation, shame, and embarrassment, and that the practices that are being used can reproduce and exacerbate stereotypes, which themselves become often self-fulfilling, including, in this case, that whole communities or groups of people are problematic and need to be singled out and treated differently. So the question is, how can we undertake to provide care for people in a way that's more caring? Now, of course, I'm conscious that many of you who are here today for this community briefing may work in the AOD sector, and it's a sector that desperately needs more resources. It's a sector where laws, including criminalisation and other policies, are imposed from elsewhere. And those who work in the sector are often constrained to a large extent in what kind of care can be provided within this context. That is itself, I think, a product of stigma, the lack of resources in the sector. Perhaps that's a discussion for later on in this session. But what I want to do now is try and take some positives out of all of this and connect these insights in human rights to a couple of other studies that I think you might relate to and which we hope will have some potential value for your work. These studies are about how we can strive to make our practices and policies as accommodating, compassionate, and inclusive as possible, or even more so than they might already be, despite existing structural constraints and challenges. So if we can go to the next slide, thanks, Sean. So here, first of all, I want to bring your attention to a recent study that colleagues and I had been looking at how we might ensure that services are as hospitable and welcoming as possible, as well as culturally safe and important. This was a study that focused on BBVs and STIs, but has broad implications for the sector. Now, I know that this is work that many of you may already be doing, but this recent project generated a toolkit for the reduction of stigma in healthcare settings, and it's accompanied by an implementation guide. Both of these are freely available at the links there. You can look those up if you need. And the toolkit contains a set of practical guidelines about how we might work on and also advocate for the reduction or ideally the elimination of stigma at different levels through examining policies and systems and practices within services. If we can go to the next slide, thanks, Sean. Oh, okay, that's all right. we'll just go back a step, sorry. I think I've missed a slide there, but this is the implementation guide that accompanies the toolkit. So there is a toolkit and then there is an implementation guide, and both of those are freely available. They do make suggestions for what we think can be very meaningful changes, including in terms of how we think about care, think about policies, think about communication, language, and the like. And I recommend those resources to you as a first step because we think they contain some potentially useful tools and ways of thinking about stigma, which, as we've explained in today's presentation, is just one way in which people's human rights might be limited. So where does this all leave us? I want to offer some reflections, and then I'm going to hand back to Sean, who's going to talk about some other possibilities for action. As Sean noted at the outset, Australia has a unique and haphazard and very limited system of human rights protection. It's a system that falls well short of that in other countries. Australians have limited human rights protections, and in the AOD space, there are constant risks to human rights, if not constant violations of human rights at play. Those of us working within the sector have limited scope to address these issues, especially when they are shaped by laws and policies that are imposed from above. But we can nevertheless advocate for better conditions and small changes and meaningful changes within practice. We can do this in a range of ways. This includes through making submissions on these issues to parliamentary inquiries, in conversations that we have with government, through advocacy work and more. We argue that human rights charters of the kind that exist in Victoria and which were important in the case of Veronica Nelson are needed in each state and territory, and that they need to be accompanied by robust and independent processes for scrutinising human rights practices of various authorities and in various settings. We also argue that Australia needs to grant power to courts to not simply identify problems of the kind that the coroner did in his findings into the death of Veronica Nelson, but to also overturn laws and policies that breach or universally recognise norms of human rights. And at the moment, importantly, those powers do not exist for courts in Australia, even though other countries have granted those powers to their courts. We might also want to join the push for a national Bill of Rights, which Sean mentioned earlier, one that provides extensive protections to people across Australia and that explicitly recognises the right to be free from torture or from cruel, inhuman or degrading treatment. Beyond this, we think the tragic case of the death of Veronica Nelson offers really important insights into the relationship between stigma and human rights. It calls on all of us to reflect on the possibility that practices are provided in ways that could be less degrading or cruel or undignified and less grounded in stereotypes and assumptions, including stereotypes and assumptions about what is natural or normal in the context of drug use and what's necessary or inevitable, the kind of suffering that was thought to be inevitable for Veronica. Finally, we've suggested some tools that might help guide anti-stigma or stigma reduction work, including that toolkit and the accompanying implementation guide. And we provide those on the basis that we can all benefit from continually examining our own assumptions and practices, as well as advocating for others to reform their practices. So now I'm going to hand back to Sean, who's going to talk to you about some other insights on actions that we think you might be able to take that mobilise the findings of the coroner in this case. Sean.
Thanks, Kate. So in this concluding section, I'll discuss how your organisation can make a submission to the Committee Against Torture. So under Article 19 of the Convention Against Torture, the Committee Against Torture is mandated to examine periodic reports on the measures that state parties, including Australia, are taking to implement the provisions of the Convention, including the prohibition on cruel, inhuman or degrading treatment. The committee's adopted a reporting procedure which consists of the preparation and adoption of a list of issues that are transmitted to state parties, including Australia, prior to the submission of their periodic report. Such lists are known as List of Issues Prior to Reporting. The written information that NGOs wish to submit to the committee for its consideration during the preparation of lists of issues prior to reporting must be received by the committee's secretariat by the 6th of October of this year. The committee will then meet for a 4-week session in Geneva in November, at which the list of issues prior to reporting will be adopted, sent to Australia, and then posted on the committee's webpage. The committee has long recognised the work of NGOs and expresses its appreciation for their reports, especially local and national NGOs, which provide direct country-specific information to the members of the committee. The first venue by which NGOs took a formal role in the United Nations deliberations was through the Economic and Social Council, and more than 6,000 organisations have been granted consultative status by the Council, including the Australian Drug Foundation, AVIL, Drug Policy Australia, and Students for Sensible Drug Policy Australia.
Hi there, folks. I think we had a little problem there with Sean freezing for a moment. So is it possible for one of the AVIL team to share those slides for us?
From here.
Thanks, Sean.
Internet connection in Ballarat can be a bit troubling at times, but yeah, I'll pick up from where we are. So as Kate was saying, the committee encourages organisations to submit information under thematic issues and to include relevant concerns and recommendations. It also encourages organisations or NGOs to coordinate their response and to submit consolidated reports with factual, reliable, precise, and clear information. So the submission needs information is not accepted, and it has to be drafted in non-abusive language. It must be relevant to the mandate of the committee, which is the Convention Against Torture, particularly Article 16, that concerns cruel, inhuman, or degrading treatment. And the information shouldn't contain names of victims, except if they're related to public cases or if the consent of victims or their families is obtained. The information submitted by NGOs must be in Word format and sent electronically to the committee secretariat by the 6th of October 2025 deadline. We've developed a submission template which you can access by contacting us, but recognise that your organisations hold the expertise on issues or concerns related to drug use stigma and the facts and information on how it manifests and who's affected by it, and recommendations that Australia can and should take to prevent it, all of which a submission should include. You know better than us here that there are a number of examples of violations which fall through the gaps in the current regime of human rights protection in Australia, including through laws that prohibit and criminalise drug use, which disproportionately impact First Nations people, inadequate access to social services for people who use drugs in the correctional system, including needle and syringe exchange programs, the use of drug detection dogs by police at music festivals, stigma while visiting healthcare services, and links between homelessness and substance use. The state of human rights for many disadvantaged groups in Australia, including people who use drugs, remains precarious, and that's why it's important to make a submission to the committee. And there are some key points which we suggest any submission should include. As a preliminary point, submissions should explicitly request that Australia's response to the committee's list of issues prior to reporting provide a candid, constructive, and comprehensive account of human rights issues arising under the Convention. Given that the focus of a periodic review is to enhance implementation of and compliance with human rights obligations on the ground, Australia's response must do more than provide generic information on Australia's legal framework and funding and program initiatives. Their response should provide details as to practical human rights outcomes, including for people who use drugs. It's also important to emphasise that the international jurisprudence on torture and cruel, inhuman, or degrading treatments expanded over time to include a wider range of issues than the traditional context of interrogation of a detainee. Interestingly, the limited jurisprudence from the committee on the issue of stigma focuses on stigma in the context of divorce. So in Essen v. Sweden, the committee considered whether the stigma that someone may suffer from a divorce constitutes torture, but found that the complainant had not adduced sufficient grounds to believe that she would run a real, foreseeable, personal and present risk of being subjected to torture. In AAS and all v. Sweden, the committee found that stigma that a single divorced woman who left her husband could be subjected to placed her at risk of persecution or torture, yet neither of these decisions makes an explicit finding for or against the proposition that stigma is in and of itself torture or cruel, inhuman or degrading treatment. So it's important that any submission emphasises how issues and concerns related to drug use stigma represent forms of cruel, inhuman or degrading treatment, using that language from the Convention. Now, we caution that a submission in and of itself won't lead to radical change. Successive Australian governments have disregarded the authority of views issued by the committee. Remedy Australia reports that there have been 7 cases lodged against Australia under the Convention, and in all of these cases, the complainant has not been fully remedied in accordance with the final views of the committee. However, a statement from the committee that drug use stigma is a form of cruel, inhuman or degrading treatment would have significant ramifications for how torture is conceptualised, both in Australia and globally. Thank you, and I'll now hand it over to Carla to facilitate any questions that you might have.
Hello, everyone. Thanks for really interesting comments in the chat, and I am going to put a couple of questions to Sean and to Kate around 2 kinds of themes. The first one is about the notion of some subjectivity in the language of these. What is, as Adrian says, what's the parameter of severe, and how is this dealt with in legal terms? Severe for one person might be moderate for another, or depending on the situations. So that's one theme. And the second is goes to that last point, Sean, about how do we enforce charters, and as you said, the Australian government has dismissed some of these things in the past. So Sean, do you want to start, or Kate?
I'm happy to start.
Yeah, do you want to take the question on severity, and then I can take the question on enforcement of charters?
Yeah, sure. So I think the point that I think it was Adrian made is a lot of this is terminology isn't clearly defined. There isn't a clear answer for what is severe and what isn't, but what we can adduce from some of the cases is that perhaps divorce-related stigma is not severe enough to reach the threshold of increasing somebody's susceptibility to cruel, inhuman or degrading treatment. But we haven't seen the question of whether drug use stigma reaches that threshold of severity. What we can say, though, is from the Nelson case that Kate was discussing, that they did make a definitive finding there that Veronica's treatment did amount to cruel, inhuman or degrading treatment. So it did reach that severe threshold to say that it did breach that particular provision under Victoria's Charter of Rights and Responsibilities. Kate?
Yeah, thanks, Sean. I might just jump in and add a couple of things to that. So, I mean, one way to think about this entire category of torture, cruel, inhuman and degrading treatment is that it's often thought of or talked about as a kind of hierarchy of wrongs. And so, in a sense, when the Convention Against Torture was introduced, the basis of that introduction, as Sean mentioned late in the talk there, was that torture was defined initially as something that might happen within the context of interrogation of a detainee. So, say, for instance, in the context of war, for instance, a prisoner of war might be captured and then interrogated and tortured. And this was thought of as perhaps the most, one of the kind of worst forms of treatment in a closed setting that one might experience. And there was a high bar to get over, a high threshold or hurdle over which you had to step in order for something to be characterised as torture, which is why that reference to severity was included. And as Sean said, it wasn't defined in the convention itself. There has been a lot of case law over time that adds or sheds light on the meaning of that. Cruel, inhuman and degrading treatment are sort of other categories which are distinct from torture and don't have the same requirements attached to them. So there is some case law, for instance, that degrading treatment means essentially humiliating treatment, and it's a far lower or lesser kind of threshold in a legal sense, even though, of course, being treated in a way that's degrading or humiliating is a significant form of harm in and of itself. So, yeah, I'll just add that, and then I might move on to the other question about enforcement of the charters. I put a bit of I started to put a bit of information in the chat there about this question, which is a really good one, and it's a complex question, and I'm going to answer it. There's a lot that I think we could say about it. Sean and I have written quite a bit on the question of human rights mechanisms and charters in Australia and their intersection with drug policy and law. I suppose I would answer it in this sense. Australia is, as Sean mentioned right at the start there, unique among Western liberal democracies in the sense that we are the only such nation that does not have a national bill or charter of human rights. So I'd start there, and I think that tells us a great deal about successive Australian governments' appetite for exposing themselves and the actions of various government departments and authorities to human rights scrutiny. There's never been a government that has indicated strong willingness to introduce a charter or bill of human rights, and so we still don't have one. And in a sense, this is why we have this piecemeal approach to human rights in Australia. The ACT decided that in the absence of the federal parliament doing anything, they would go ahead and introduce their own state-based charter to recognise human rights, and then Victoria followed, and then Queensland followed. But each of those charters is itself a step in the right direction, but is inadequate for a range of reasons. And one of those reasons is that it doesn't grant power to courts, wide-ranging powers to courts to hear human rights cases, standalone human rights cases, and it doesn't grant wide-ranging powers to courts to overturn laws and policies if they are in violation of rights. Courts can make findings that human rights have been violated and the like, and then it's up to those authorities to go back and correct their practices or policies. So they don't have, often in legal circles, people talk about these charters as lacking teeth. And so in that sense, the only way really that you could, and I think the question used the language of enforce charters, give charters more teeth, would be for those parliaments to go back and change those laws, to grant further, more widespread powers to courts of the kind that some other countries have, like Canada, for instance. And some of you will have heard me talk about this before, but Canada is an example of a jurisdiction that's a lot like ours. We have a similar history. We're a Commonwealth nation. We have a legal system that is in many respects similar to Canada's. They have a charter of rights and freedoms that operates with much more wide-ranging powers, and it grants powers to courts. So as many of you will remember, back in 2011, there was a decision by the federal government in power in Canada at the time to try and close down what was at that stage Canada's only supervised injecting facility. That's a facility based in Vancouver, Insight. And a group came together to bring legal proceedings designed to try and block that and keep Insight operating. And part of what they did was argue that it would be a violation of their human rights to close down the centre. And they succeeded. And that's why Insight stayed open. And that is because the court in Canada had teeth. The charter had teeth. It granted the court the power to push back and say that rights were being violated. So I suppose, yes, the only way that we will really have a much more comprehensive system, or one of the ways, we would have a much more comprehensive human rights system in Australia is if those charters were reformed.
Okay, I can also see a comment from Yvonne about refusal of treatment in emergency departments, and Hannah's the potential link and application here, particularly for treatment or lack thereof. Is this torture? How do we understand this?
I'm happy to respond, and Kate might want to add in some things. So one of the limitations of our human rights acts across those three jurisdictions, Queensland, the Australian Capital Territory and Victoria, is that they've got inconsistent protections or recognitions of different human rights. So, for example, whilst Queensland recognises that a person has a right not to be refused emergency medical treatment that's immediately necessary to save the person's life or prevent serious impairment, and I'm using the language from that act, that isn't within Victoria's or the Australian Capital Territory's Human Rights Act. So that is one limitation, this sort of discrepancy between what rights are protected. That said, though, what we're suggesting is that perhaps the refusal of treatment, especially if it were related to stigma, could be considered in and of itself cruel, inhuman or degrading treatment, which is prohibited under all of the Human Rights Acts in Victoria, the Australian Capital Territory, and in a separate provision under the Queensland Human Rights Act as well too, and might of itself breach some other areas of law as well too. Kate, was there something further that you wanted to add to that?
No, I think that's right. I think that's right, Sean. I agree. I think that's the kind of reading that the Veronica Nelson decision does open up for us. It opens up the possibility of looking at all kinds of practices in, as I said earlier, in a range of settings, including in hospitals. Emergency department settings is one, but hospitals more broadly. Obviously, there are many instances in which we know that people who have a history of drug use, or people who are assumed to be drug users or drug seekers, those not my language, of course, but the sort of language that's often in circulation in those settings, are sometimes refused pain-killing medication or certain kinds of treatment turned away. Those practices, as Sean said, I think we can argue that they are cruel, inhuman and degrading, in part because they're based on stereotypes and assumptions of the kind that different from, but similar to the kind that Veronica Nelson had been subjected to. So in her case, some of the stereotypes and assumptions that were in place that the coroner found were stigmatising were assumptions like that suffering and withdrawal was natural and normal and that she would just have to ride it out. I think there was also an assumption, or there was evidence that at least some people who were working in that setting at the time believed that she was kicking up a fuss, trying, I'm not sure of the exact wording, it's not in the forefront of my mind from the coroner's findings, but essentially that she was unnecessarily bothering everybody in terms of ringing the intercom repeatedly and could be ignored, making trouble essentially. And I think we can see parallels, or that there's an analogy or a closeness between those kinds of concerns that the coroner had in that case and the concerns that I think is Yvonne's mentioning here in the chat about how people might be treated when they turn up to a hospital or to an emergency department, or really to any healthcare setting where people are assumed to be untruthful or to be exaggerating their concerns, exaggerating their symptoms, really just seeking pain medication. All of those things are similarly, I think, potentially grounded in stigma. And so in that sense, I think we would all say, Carla, Sean and I would all say that that's I think a very good example, Yvonne, of where the kinds of arguments and findings that were made in Veronica Nelson's case could perhaps be transferred here. The other thing I'll just mention very briefly, and then I'll hand back to you, Carla, is one thing we haven't mentioned here, but which Sean and I again have written about separately, is the existence of what's called the Mandela rules. And I think many of you will be familiar with the Mandela rules. That's the sort of shorthand term for them, but they are a set of principles that apply to the treatment of prisoners. And there is a provision in the Mandela rules that states that people in closed settings, in prison settings, are entitled to the same standard of care that people in the general community might receive. That's a sort of separate right or separate entitlement that people have. That again, we think that, you know, the coroner clearly gestured towards those problems with the equivalence of care that Veronica received in this setting, making observations about pharmacotherapy, the lack of availability for Veronica and the like. And so that would be another instance where there are, I think, questions to be raised in particularly in prison settings about the equivalence of care.
And thanks, Kate and Sean. And some of what you mentioned goes to comments made by Fiona and Tia about aged care and end of life care. And you know, that's not applicable to the Mandela rules because it's not in prison. I'm assuming there it's in the community, but that same kind of refusal of care based on assumptions or attitudes. And there's also an element, another structure that we can draw upon, which is the national standards, and the aged care sector released new draft standards for comment earlier this year, which included that all aged care clients had the right to care that was respectful, discriminatory, and held up their privacy. Sorry, did I say I'm a bit jet lagged? Discriminatory or non-discriminatory? You know, the right one. That's what we're talking about. And so that's another framework we can use to think about aged care in particular. Healthcare standards for the rest of the health provision outside of aged care doesn't have those words as yet. There's another great question from Rush, not a silly question at all, Rush, but why is it that Australia is so behind the 8 ball in regards to take up of human rights charters? Is it that $1 million question?
I can take this up, and perhaps Kate might have some further to add. So what I can say is that the Commonwealth Parliamentary Joint Committee on Human Rights has recently tabled a report calling for Australia to implement a Human Rights Act. The government hasn't accepted that recommendation. That said, during the previous Labor government, there was also a discussion around establishing a Human Rights Act, which they unfortunately didn't take up, but they did establish a piece of Commonwealth legislation that essentially requires all Commonwealth laws during the lawmaking process to be subject to scrutiny to determine their compatibility with human rights. So there is that limited mechanism under Commonwealth law to ensure that bills that go before the Parliament are scrutinised to assess their compatibility with international human rights to which Australia is a signatory. The Australian Human Rights Commission's also launched a campaign around a National Human Rights Act, and as we mentioned in the chat, there's also the Human Rights Law Centre's campaign around a National Human Rights Act. If we knew exactly why the government was reticent to legislate in this regard, that would be indeed the $1 million question. But what we would say is, and I think what came out during our presentations, is that it's going to take a variety of different stakeholders from a variety of different community organisations to continue to put the case to the federal government, but also those governments where in those states and territories where there currently isn't a Human Rights Act, which is all the states and territories outside Queensland, Victoria and the Australian Capital Territory, to legislate for this, and to ensure, as Kate was saying, that those human rights protections are robust, but also the mechanisms for enforcement are robust. So it's not just reliant on a parliamentary committee to assess human rights compatibility with legislation before it comes into force, but to ensure that legislation and indeed the actions of public authorities are consistent with human rights principles.
I might just jump in and add a couple of things to that, Sean. Yeah, it is the million-dollar question. For earlier, Sean and I in the last few years have been undertaking some research on human rights and drug policy more broadly. And part of what we did for that project was interview 30 Australian parliamentarians who had experience with human rights charters. So that's people in those jurisdictions that have those human rights acts. Now, it was a qualitative piece of research, so this is by no means a representative sample of parliamentarians more broadly. But what I can say from doing that work is that, you know, part of what we asked those parliamentarians is how they felt about human rights generally, and then how they felt about the intersection between human rights and drug policy. And again, this is something that we've written about, and I'm very happy for anybody to contact us if they'd like copies of our reports or publications on these points. But what we would say is that individual parliamentarians have a wide range of views about human rights. Some are very supportive of human rights acts and charters and feel that it's a very, that it's an important part of the legislative architecture in the country for the actions of parliaments and departments to be subjected to this kind of human rights scrutiny. But there were certainly a number of parliamentarians that we interviewed who were pretty dismissive of human rights. And what we do know from past reviews of human rights acts and inquiries of the kind that Sean mentioned, and other sort of public statements by parties and individual parliamentarians, is that at least for some people who are in Parliament in Australia, there is a concern that the introduction of human rights acts or the reform of human rights acts that would give more teeth to those acts and more power to courts would open the floodgates. It's the kind of language that parliamentarians or legislators sometimes use when talking about law reform. There's often a concern that if you make a reform to law, it'll open the floodgates, that all kinds of actions and activities can be subject to human rights scrutiny, that courts will be filled up with court cases where people are arguing that their human rights have been violated, that this will be both financially costly and a drain on court resources and time, and that it will have really significant implications for a range of government departments that could be quite debilitating. Now, that's the argument that's sometimes made. And of course, I think we would say that opening up the actions and activities of various authorities to human rights scrutiny is a good thing, and that it can be carefully managed because it's done in many other parts of the world, like Canada, as we mentioned earlier. But that's I suppose some kind of anecdotal reflections on what the reticence sometimes is. But I do think, as Sean said, that there is some momentum building, in part through that recent parliamentary committee joint parliamentary committee report.
And can I just pick up on one point? So there are, of course, limitations with the Parliamentary Joint Committee on Human Rights and its process of scrutinising bills, in the sense that it is a committee that is dominated by government. So it tends to, if it's a government bill, that is a political consideration that factors, I think, probably into the committee's thinking. That said, though, one area where the committee has been really effective is in terms of a series of proposals under the former Liberal government to legislate mandatory drug testing for people receiving welfare payments. In that case, the committee quite strongly held that that legislation was inconsistent with human rights. And in part, as a result of that committee's findings, the government didn't proceed with some of the legislation in that area. So that's one area where there has been some wins through that existing mechanism of what we call parliamentary human rights scrutiny, where legislation is scrutinised by a parliamentary committee before it's passed to determine its compatibility with human rights. And of course, the other area is under the Victorian ACT and Queensland charters, there's an obligation on public authorities to not act inconsistently with human rights and to consider human rights in their decision making. Now, as Donna mentioned, one of the limitations of particularly the Victorian Charter is that it has an exemption for the Adult Parole Board and the Youth Parole Board. So definitely for advocates that are based in Victoria, that is an issue to take up with the Victorian government to remove that particular exemption, so that the parole boards are required to not act incompatibly with human rights, but also importantly to consider human rights in their decision making.
Okay, thank you. With my jet lag brain, I am trying to look through the comments and, I guess just to reiterate this analysis, we're really proud of this analysis of the work from the coroner in this terrible case of the death of Veronica Nelson. But we also want to bring it to life and make it useful, and hence why we work with Able to put on this webinar and also produce a template that people can use in their own submissions to the various bodies that are useful and speak to these issues. So very happy for you to get in touch with me, and I can distribute this template. And this is an ongoing discussion. It's very complicated. There's numerous elements of the law and various bodies that have a bite, but we're all, I guess, in this together, thinking about how we can activate this newer ruling from the Victorian Coroner's Court to bring some change to the bodies that have some power, if they choose to use it, over the experience of people who use drugs. I'm thinking that we might be towards the end of any issues. Just checking with Kate and Sean if there's anything you would like to jump back in on before we wrap up.
No, I might just say thank you very much to Ellie, who's just put something in the Q&A there. So I mentioned earlier that the work that Sean and Carla and I have just done on the Veronica Nelson case is really part of a much longer project, a project that's not at an end, by the way, because there's a lot more to say about human rights and drug policy, of course. But it is part of a larger project. And Sean and I have recently released a report, which you can hopefully access there through the link that is just now in the chat, that goes into a bit more detail about the human rights landscape, both in Australia and internationally, that talks a bit about the findings from interviews where we spoke with both parliamentarians and then experts in both human rights and drug policy from around the world. So I hope that you might have a look at that. We do talk a bit about the Veronica Nelson case and our findings there too. And you're very welcome to email both Sean, Carla and I if you have any questions about that. And I see that there's a question in the chat about whether we can share the slides with everybody who registered. And yes, please do. I think there's no problem with us doing them, just looking at Sean and Carla. Because, yeah, as Carla mentioned, I suppose the only other thing I would say is that this is a very complicated area of law. I know there's a lot to digest today. So please do feel free to email us if we can help.
Yes, and I might just pick up on that question from Ellie as well too. And also somebody mentioned the Universal Periodic Review. As Kate said, this is extremely complicated, but I'll try and in this closing bit give a very clear as I can be summary of the different bodies that are involved. So there's essentially two key bodies which organisations may be interested in. The first is the United Nations Human Rights Council, and then the second is the United Nations Committee Against Torture. So the United Nations Human Rights Council does what's called a universal periodic review of Australia, looking at its human rights compliance across the whole suite of human rights, not just specifically torture and cruel, inhuman or degrading treatment, but all of Australia's human rights obligations. And I note that Scarlet Alliance and a number of other different organisations have been involved in a submission to the United Nations Human Rights Council that addresses those issues. We too have been, and are hopeful that there might be something in that submission that addresses drug use stigma. Second to that universal periodic review, the UN Human Rights Committee also considers individual cases. So perhaps the most famous of these was the Toonan case, where a man from Tasmania took a case regarding what was then the laws criminalising homosexuality in that state, and the Human Rights Committee found against those laws. That was very significant. It led to the eventual decriminalisation of homosexuality in Tasmania. So that's just one case of where an individual making a complaint to a UN body has led to significant law reform outcomes. So you've got the periodic review, and you've also got the ability to make individual complaints. Similarly, the United Nations Committee Against Torture also does what's called a periodic review, looks specifically at Australia's compliance with the Convention Against Torture, which includes its compliance with the prohibition on cruel, inhuman or degrading treatment. What we are advocating for is for your organisations to make a submission to that committee as well too, that specifically looks at the issue of drug use stigma and issues of cruel, inhuman or degrading treatment against people who use drugs. That submission is due in October of this year, and you can contact us for a template that we've developed to assist your organisations with doing that. And I should say that this is not limited to drug use stigma. A lot of people have brought up stigma against older people in aged care settings, against sex workers, against other groups as well too. So that those are all kind of issues that you could raise in the rubric of cruel, inhuman or degrading treatment. And then perhaps fourthly, individuals can make complaints to the Committee Against Torture. And we discussed during my presentation a couple of those findings from complaints about the complaints against Sweden in relation to divorce-related stigma. So again, that could be an opportunity for individuals to make complaints there as well too. As Kate mentioned, and as I did as well too, it doesn't necessarily mean that Australia will implement the recommendations that come about from the committee, but it does act as a strong stick, if we can call it that, to spur action from Australian and state governments and its state and territory governments as well too. So hopefully that gives you a bit more clarity on those two key bodies, the Human Rights Committee that does a universal periodic review of all human rights and can take complaints, and the Committee Against Torture, which is doing this periodic review. Submissions are due to them in October, and they can also take individual complaints as well too. But again, just to reiterate the points that Kate and Carla have made, do feel free to reach out to us. It is a confusing area, but we've developed some templates and information that can assist you and guide your organisations in how to engage with these complex United Nations mechanisms.
Okay, great. This has been a really fascinating discussion, and we really appreciate the opportunity to engage with the AVIL membership and colleagues around the country and overseas. I saw someone from New Zealand on the chat. Hello. So we're all trying to do good in the world together. So yes, please do see that as an invitation to reach out if we can assist or learn from you, because I know some groups and individuals are really expert in these processes, and we all need to share each other's knowledge and expertise to get something done. So I think I'm going to wrap it up here and let us all go on with our days. Again, thanks to Abel for hosting this and being interested in the work that we are doing. And let's see if we can get something happening. So, well, just checking with Emily if you want to come back in or if we are good to sign out.
Sure, I can close up if you like, Carla. Thanks everyone. Thank you, all panelists. Like honestly, it was just such an amazing topic to like explore, and I just can't thank you all enough for being here. We'll leave it there and see everybody at the next webinar.